Counties and county seats. Section 63. Area of counties, boundaries, creation and abolishment of counties. No new county shall be created by the General Assembly which will reduce the county or counties, or either of them, from which it shall be taken, to less area than 400 square miles, nor shall any county be formed of less area, nor shall any boundary line thereof pass within less than 10 miles of any county seat of the county or counties proposed to be divided. Nothing contained herein shall prevent the General Assembly from abolishing any county. The framers of the current Constitution added this section to curtail the creation of counties, 119 of which had been created by 1890. Delegates complained that Kentucky had too many counties, most took out more than they paid into the state treasury, and the smallness of some contributed to their feud-ridden nature. The delegates borrowed the 400 square mile criterion from a number of state constitutions, including those of Pennsylvania, Florida, Missouri, Michigan, Maryland, Kansas, Iowa, Indiana, Illinois, and Arkansas. They specifically authorized the General Assembly to abolish counties because, while realizing that it was unlikely the General Assembly would ever abolish a county, they hoped the threat of such an action might cause the residents of feud-ridden counties to reform themselves. In Zimmerman v. Brooks in 1904, the Kentucky Court of Appeals held that the General Assembly had unconstitutionally created Beckham County because the creation reduced the size of a neighboring county to less than 400 square miles, the area of the new county was less than 400 square miles, and the boundary line of the new county lay within 10 miles of the county seats of certain neighboring counties, all in violation of Section 63. Section 64. Division of county or removal of county seat, election required, minimum population of county. No county shall be divided, or have any part stricken therefrom, except in the formation of new counties, without submitting the question to a vote of the people of the county, nor unless the majority of all the legal voters of the county voting on the question shall vote for the same. The county seat of no county is now located, or as may hereafter be located, shall be moved, except upon a vote of 2/3 of those voting, nor shall any new county be established which will reduce any county to less than 12,000 inhabitants, nor shall any county be created containing a less population. This section provides a further condition to the creation of new counties and makes it more difficult to move county seats and county boundaries. On at least one occasion, a land speculator had persuaded the General Assembly to move a county seat so that he could convert a farm into town lots in the new center of local government. On numerous occasions, individual residents had secured legislation changing county boundaries so that they could reside in a neighboring county to run for political office or for some other personal reason. Although voters approved a proposal to move a county seat by a margin of nearly 3-1, the proposal failed because less than half of those who voted in the general election supported it as required by Section 64, in Hogg v. Baker, 1895. Where a boundary line between two counties has been judicially determined and voters have not approved a change in such line, an act of the legislature fixing a different boundary line is in violation of Section 64, in Commonwealth v. Thomas, 1955. However, the Attorney General has issued an opinion that a county courthouse may be moved within the county seat without voter approval. The Special Commission on Constitutional Review of 1987 recommended that Section 64 be amended to facilitate the merger of local and county governments. Section 65. Striking territory from county, liability for indebtedness. There shall be no territory stricken from any county unless a majority of the voters living in such territory shall petition for such division. But the portion so stricken off and added to another county, or formed in whole or in part into a new county, shall be bound for its proportion of the indebtedness of the county from which it has been taken. This section constitutes a further restriction on the creation of new counties and provides that territory stricken from one county and added to another shall remain liable for its share of the indebtedness of the county from which it was stricken. The Kentucky Court of Appeals has ruled that Section 65 is self-executing and that the territory stricken from a county is liable for its share of the indebtedness of the county from which it was stricken even without legislation to that effect. However, the rest of the new county is not liable for any of the debt, in Whitley County v. Wood, 1914.
Impeachments. Section 66. Power of impeachment vested in House. The House of Representatives shall have the sole power of impeachment. Section 67. Trial of impeachments by Senate. All impeachments shall be tried by the Senate. When sitting for that purpose, the senators shall be upon oath or affirmation. No person shall be convicted without the concurrence of 2/3 of the senators present. Section 68. Civil officers liable to impeachment, judgment, criminal liability. The governor and all civil officers shall be liable to impeachment for any misdemeanors in office. But judgment in such cases shall not extend further than removal from office, and disqualification to hold any office of honor, trust or profit under this Commonwealth, but the party convicted shall, nevertheless, be subject and liable to indictment, trial and punishment by law. These sections, which contain language very similar to that found in the Pennsylvania Constitution of 1790, can also be found in almost the same form in the previous 3 constitutions. The Kentucky Court of Appeals has held that wherever the Constitution has created an office and fixed its term, and has also declared upon what grounds, and in what mode an incumbent of such office may be removed before the expiration of the term, it is beyond the power of the legislature to authorize removal of the officer for any other reason or in any other mode, in Commonwealth v. Howard, 1944. The court also ruled that an officer may be indicted and punished for malfeasance in office before being impeached, in Commonwealth v. Roe, 1902.
Thank you for viewing this history of the Kentucky Constitution. For more information, please see the following references. Citizen's Guide to the Kentucky Constitution by the Legislative Research Commission, available online. Or the book, The Kentucky State Constitution, by Robert M. Ireland, Oxford University Press.